Today is Thursday, September 24th, 2015. It's 3:17 p.m. We are at our 5th annual opening of the court ceremony protest. We've been doing this since 2011. Please allow me to speak for a moment about some freedom of information of work that both myself and FixCAS.com did back in 2012. Doing the reading that is absolutely required in order to be able to protect your rights in this system. We came to be aware of a 1999 Bill 6, the Child and Family Services Amendment Act. It was a Mike Harris government initiative. It was an amendment to the Child and Family Services Act, which was done for very, very specific reasons. Specifically, the Mike Harris government wanted to use the Children's Aid Societies and Child and Family Services Act mitigation to attack and do damage to what they call low-income Ontarians, people who would have to rely on Legal Aid Ontario representation in court. And so they did this thing called the 1999 Bill 6 Child and Family Services Amendment Act. You can Google and see our work, the freedom of information work we did. If you Google FixCAS.com, Protecting Vulnerable Children, you'll come to the report. Anyways, it turns out from reading some academic papers written by a Queen's University law professor by the name of Nick Balla, who, as far as I'm concerned, is one of the only academics in Ontario to actually speak out and write academically about the unfairnesses of the child protection litigation fraud. And I learned from Nick Balla's paper that from 1997 to 1998, the province of Ontario was operating something called the Expert Panel on Child Protection. It was an 8-member panel. It was led by a former Children's Aid Society lawyer, now Superior Court Judge, Mary Jane Hatton. Hatton was actually a lawyer for the Children's Aid Society at the time she was made a judge. I believe that she was originally made a provincial court judge and then later promoted. The Expert Panel on Child Protection compiled a 77-page report called Protecting Vulnerable Children, which made numerous recommendations for changes to the child protection system. And Bill 6 was at least partially based on the panel's report. We have the report posted to FixCAS.com. But think about this for a minute. Here we had this important 77-page report, and the report wasn't made available publicly until 2012. Think about all the university political science professors, law, social work, all those professors, all those academics who would have been aware of this report, but never in the public's interest could be bothered putting their academic knowledge to work and posting the report for public benefit. And that's one of the things that we have seen in our freedom of information work. There is a desperate dearth of any type of public interest work on the part of academics in terms of acquiring and posting dirty data. They're just not doing it for us. So it comes down to the journalists, and the Toronto Star does incredible work, and basically individual people to do that hardcore freedom of information work. So we obtained this Protecting Vulnerable Children report, and we posted it to FixCAS.com. On the second last page of the report, it has brief biographies of the 8 panel members. And you want to talk about Children's Aid Society stacking the Children's Aid Society deck. Gentlemen, any opinions on the state of the administration of justice in the province of Ontario? Do you you agree that the courts of Ontario should be brought into freedom of information? So people can do freedom of information work on the courts? So anyways, we have the biographies of the 8 panel members. And you want to talk about CAS stacking the CAS deck. Oh my God. 7 of the 8 panel members, it could be very, very easily argued, derived a significant portion of their income directly from child protection litigation. So they had a vested, very obvious, vested financial interest in the increase and expansion of child protection litigation. The only panel member who perhaps didn't have that vested interest was elementary school principal, and he was one of the panel members, but he was the only panel member who didn't have such an interest. One of the panel members was not only a board member for 2 different children's aid societies, and you can read it right on page 76 in her biography. She was also a foster parent, and she trained other foster parents in the CAS system. So they really stacked the deck. Not only did they stack the deck with people who were pro-CAS and pro-expansion of stranger danger foster care, they did not have one single family preservation type activist on that panel. And so, of course, the report that they produced was going to be wickedly biased and slanted, and that resulted in 1999's Bill 6, which legislatively empowered the Children's Aid Society to go on a litigation slaughter against the children and families of the province of Ontario. Now, fast forward to just a couple months ago, and I was on the internet, and I found a 2005 Law Times article, which I think was titled Proposed Adoption Law, something about a proposed adoption law. And it was written by Carol Curtis, she's now a judge, and we discovered in that article that in 2005, the Government of Ontario commissioned the Child Welfare Secretariat to produce a report which contained 40 recommendations for potential changes or possible changes to the child protection system. It's all in Carol Curtis's one-page article. I immediately put in a Freedom of Information request with the Ministry of Children and Youth Services to obtain this Child Welfare Secretariat authored report, 40 recommendations. I got from the Ministry of Children and Youth Services, I got what was the most fallacious response I've ever received. The Ministry of Children and Youth Services responded, and the correspondence is posted to my Scrutinizing the Justice System Participants Facebook page. You can see it in the files section. The Ministry of Children and Youth Services responded that they had already provided me with this 2005 report. They said that I had already requested it and they had already provided it to me. And they provided me with a letter that they were saying proved their point. The letter which proved their point was my Freedom of Information request, or their response to that request, for the Protecting Vulnerable Children document, which I did get. And so the Ministry of Children and Youth Services is trying to say that a 1998 report done by the expert panel on child protection is the same as this 2005 report done by the Child Welfare Secretariat. It was incredibly fallacious. So I appealed that denial of access to the Information and Privacy Commissioner. And then we started thinking, and we said, okay, that's not satisfactory. So my good friend Rose White and I put our heads together, and we came up with the idea of submitting the same request for the same document under her name, which we did. And Rose stated that that I would be her agent in this effort, and we've received the first response from the Ministry of Children and Youth Services. So we're still on the hunt for that 2005 Child and Welfare Secretariat document. Gentlemen, I know he's laughing. I know it is laughable, isn't it? Isn't the administration of justice in the province of Ontario just a pathetically laughable thing? And don't you feel shame for being part of it? Of course you don't. Your wallets are too heavy for you to feel shame. All those public dollars in your pocket. So, that's part of the freedom of information stuff. And all due respect to people who have various opinions on what needs to be done here in the province of Ontario, whether it's giving the Ombudsman oversight of the CASs, or whether it's obligating child protection workers to belong to a professional college. I know for an absolute fact, because I've been living it since 2012, that there is no other tool, I call it a weapon, there is no other option better than freedom of information work when it comes to holding the justice system participants to account. Although so very, very cowardly, the judges in the courts of Ontario are desperate to keep themselves from being brought to the freedom of information. That's why nobody has respect for the administration of justice. We understand the technical parts of the argument that the judges are desperate to keep themselves from being brought to the freedom of information. And just so people understand, by comparison, there are countries that allow their citizens to do freedom of information work on the courts. I'm pretty sure America does. I know for a fact South Africa and Israel do. And so if countries like that can allow their citizens to do freedom of information work on the courts, what does it say about Canada that they don't allow it here? Westminster, Buckingham Palace, read university-level political science books. Read university-level criminology, social work, law, all of it. You have to read the university-level stuff. You can get it brought into your own public library through the Interlibrary Book Loan Program. It doesn't matter if it's not in your library. You just give your librarians the book titles. I email the book titles to my librarians, and they'll go out and bring them in. Even if those materials are only at university libraries, they'll bring those materials in. But here's an interesting fact. The only libraries in the province of Ontario which are exempt from participating in interlibrary loan are, get this, Ontario's law school, university law school libraries. Those are the only libraries in Ontario where people cannot obtain materials from using interlibrary loan. Westminster, Buckingham Palace.